While most of the country slept early this morning, the Supreme Court silently restructured how authority operates throughout America. No advance notice, no public discourse, no oral proceedings, just an abrupt 6-3 emergency decision that will begin impacting countless citizens starting next month. And here's what's barely being reported. This ruling doesn't merely adjust a particular regulation or settle a limited legal question. It fundamentally transforms how constitutional protections function in this nation. Whether you've noticed it or not, the constitutional foundation you stand on shifted dramatically during the night. This goes beyond another typical court announcement. This represents a seismic redistribution of authority among the judiciary, the executive branch, and ordinary Americans. In state legislative chambers, government departments, and judicial proceedings spanning from the nation's capital to the West Coast, the entire framework was reconstructed within hours, and the vast majority remain unaware of what transpired. Before we examine the specifics that are already creating ripple effects throughout our legal infrastructure, ensure you're following along, because this is precisely the type of judicial determination that doesn't seem consequential until it directly affects your daily existence. In the early hours, the Supreme Court issued a 6-3 emergency determination in Trump v. Casa, Inc., via what legal experts call the shadow docket. This means no spoken arguments, no extended consideration period, no comprehensive public documentation, merely a swift verdict that instantly transforms the constitutional terrain. The case ostensibly concerned a significant executive directive related to citizenship by birth. However, the court leveraged this opportunity to accomplish something far more substantial. It resolved a multi-year internal conflict regarding judicial authority that has been quietly escalating beneath the surface. Central to this determination is a legal mechanism most citizens have never encountered, yet have depended upon for generations: universal injunctions. The Supreme Court just determined that federal magistrates can no longer implement universal prohibitions that prevent a statute or regulation from enforcement throughout the entire nation. And though this may seem like specialized legal terminology, the ramifications are massive. This singular ruling rewrites how constitutional disputes function across America. For roughly the past quarter century, when individuals contested a statute they considered unconstitutional, a single federal magistrate could provisionally halt that statute's enforcement nationwide while the litigation proceeded through appellate courts. One magistrate, one courtroom, one directive, and the entire federal apparatus had to suspend enforcement across all jurisdictions. That authority was exercised in immigration matters, medical coverage controversies, ecological regulations, firearm statutes, employment standards, and electoral procedures. A magistrate in California could freeze enforcement in Texas. A magistrate in Texas could prevent implementation in New York. That period has now concluded. The Supreme Court didn't simply restrict that authority, it eliminated it. Based on judicial documents examined this morning, there are presently 68 active universal injunctions affecting matters ranging from pharmaceutical availability to occupational safety and electoral oversight. Under this revised paradigm, numerous injunctions could dissolve within the subsequent 60 to 90 days as inferior courts rush to modify their directives. And the chronological implications could not be more volatile. We are advancing directly into an electoral season with major confrontations over immigration, healthcare, constitutional rights, and voting regulations. This determination just altered how each of these conflicts will unfold. The majority position was authored by Justice Amy Coney Barrett and supported by Chief Justice Roberts, alongside Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their reasoning depends on a straightforward yet revolutionary assertion. The Judiciary Act of 1789 never authorized magistrates to safeguard individuals who aren't actually participants in a legal proceeding. According to the majority, a magistrate's function is to adjudicate particular controversies between particular individuals, not to function as a national veto against presidential or legislative action. However, the most provocative reasoning didn't originate from the primary determination. It emerged from Justice Gorsuch's accompanying analysis. He traced judicial practice from the founding period through the late 19th century and discovered something noteworthy. American courts did not issue prohibitions safeguarding individuals who were not directly participating in the proceeding. Magistrates consistently declined to extend remedies beyond the actual litigants appearing before them. Justice Thomas advanced even further, contending that universal injunctions represent a contemporary innovation that promotes forum shopping, where advocacy organizations search for sympathetic magistrates to terminate policies they resist. According to the majority, that period is now formally terminated. The dissenting justices perceived this situation very differently. Spearheaded by Justice Sotomayor, they cautioned that eliminating courts' universal remedy authority grants the executive branch capacity to enforce unconstitutional regulations while individual lawsuits proceed gradually through the system. They contended this determination risks converting constitutional protections into advantages reserved exclusively for those possessing resources to litigate. And that, presumably, concludes Part 1, because the genuine impact of this ruling isn't theoretical. It's already manifesting in real time throughout immigration, firearms legislation, healthcare, elections, and the economy. Within 48 hours of the determination, the constitutional landscape transformed dramatically. State attorneys general from 18 jurisdictions submitted emergency petitions in federal courts, attempting either to maintain existing injunctions or to immediately implement statutes that had been suspended for years. Texas moved aggressively to limit injunctions preventing immigration enforcement. Florida submitted emergency documentation targeting social media oversight and electoral procedures. California and New York responded with submissions of their own, desperately attempting to maintain national prohibitions on federal regulations they oppose. Behind closed doors, the Department of Justice organized emergency strategic sessions with hundreds of federal prosecutors across dozens of ongoing cases. The White House Counsel's Department quietly alerted federal departments to prepare for statutes they assumed were blocked to suddenly become effective, possibly within weeks. The rapidity and magnitude of the response reveals everything. Legal strategists interpret this as a substantial authority transfer toward the executive branch and a catastrophic setback to judicial resistance. Advocacy organizations across the political spectrum are now scrambling. Organizations like the ACLU, NAACP, and Alliance Defending Freedom depended on universal injunctions as their most formidable legal instrument. That instrument has now vanished. Major legal practices are alerting clients that civil liberties and constitutional litigation could now require 5 to 8 times greater expenditure because instead of submitting one lawsuit, litigants may need to file in dozens of jurisdictions. This is where the determination becomes profoundly personal. Immigration enforcement represents ground zero. There are currently 19 injunctions restricting ICE operations nationwide. Under the revised framework, Those safeguards may only apply to particular litigants in particular districts. Immigration enforcement could now appear completely different depending on your location. The identical situation applies to firearms rights, medical care availability, ecological safeguards, employment regulations, and electoral statutes. Your constitutional protections may now depend on your geographic location. We are potentially entering a period where federal statutes exist theoretically, but are implemented inconsistently throughout the nation. 50 interpretations of identical statutes, one constitution, but fragmented protection. As we advance toward the 2026 electoral cycle, this determination establishes conditions for unprecedented legal turmoil. Electoral administrators are already warning of a catastrophic scenario where voting regulations vary not by state statute, but by judicial geography. Corporate America is also experiencing concern. Multi-jurisdictional corporations are now confronting the possibility of complying with different federal regulations in different regions. Banking, healthcare, technology, and pharmaceutical sectors are all cautioning about substantial compliance expenditures and regulatory confusion. Projections suggest this legal fragmentation could impose tens of billions of dollars annually on businesses. However, this narrative extends even deeper. This determination is part of a broader Supreme Court approach that depends heavily on the shadow docket, where high-impact rulings are issued without comprehensive documentation or clarification. By issuing emergency directives that effectively transform the statute, the court is asserting authority over inferior courts in ways that were inconceivable just a decade ago. Critics caution this generates a deterrent effect where magistrates hesitate to prevent even manifestly unconstitutional actions for fear of immediate reversal. For constitutional rights, the implications are substantial. For generations, broad injunctions were the principal instrument used to dismantle systemic discrimination. Now, courts may only safeguard the limited number of individuals who litigate, leaving thousands of others vulnerable unless they submit their own cases. Justice Jackson characterized this as an existential threat to the rule of law, cautioning that it generates zones where the Constitution effectively doesn't operate. The Supreme Court's 6-3 emergency determination in Trump v. Casa, Inc. didn't just modify a legal procedure. It transformed the meaning of protection in America. If your right to vote, to equal protection, or to due process only exists if you personally possess the resources to litigate, then those rights begin to resemble less like guarantees and more like privileges. We are entering a new period of American jurisprudence. Whether this represents a restoration to constitutional originalism or a dangerous fragmentation of justice depends on your perspective. However, one thing is certain. The legal patchwork is here, and its consequences will define immigration policy, elections, civil rights, and economic stability for years to come. If you want to stay informed about these changes, make sure you're subscribed, hit the like button, and tell me in the comments, was the Supreme Court correct to terminate nationwide injunctions, or did it fracture the rule of law? Your response may reveal more about the future of America than you realize.